It's been a week of historic rulings by the U.S. Supreme Court. Major victories for gay rights advocates with the striking down of the Defense of Marriage Act.
DOMA's down. DOMA's unconstitutional.
As well as California's ban on same-sex marriage. Plus, rulings on affirmative action and the Voting Rights Act raise questions.
I'm here to say we need to act.
President Obama calls for sweeping action on climate change with mandatory restrictions on greenhouse gas emissions.
I don't have much patience for anyone who denies that this challenge is real. We don't have time for a meeting of the Flat Earth Society.
And Bay Area commuters brace for transit chaos with the possibility of a BART strike next week. Coming up next.
Good evening, I'm Scott Schaefer. Welcome to This Week in Northern California. This afternoon and evening, gay and lesbian couples filled San Francisco City Hall to get married. A federal court made it possible today for same-sex marriages to commence immediately by lifting a court-ordered stay. The first to be wed were Chris Perry and Sandy Steer, one of the couples that challenged Proposition 8, kicking off what is sure to be a historic gay pride weekend.
It's been a celebratory week for advocates of same-sex marriage, as the U.S. Supreme Court struck down both the Federal Defense of Marriage Act and Proposition 8, California's ban on same-sex marriage. For Julie Dorff and Jenny Olson, who were already legally married in Canada, the road to marriage equality at home has been long and sometimes rough on their young family.
There's lots of ways that it really concretely impacts us, but mostly it's about letting our kids know. I mean, they were really impacted by the voters telling us that our family wasn't as equal as the families of all of the other kids who have straight parents at school.
You know, it was a really hard time, especially when she was little and trying to make sense of it. It's been a huge political education for them, and I feel like they're, you know, the good thing is that they're really sophisticated in terms of their understanding and analysis around our civil rights.
A map in their dining room tells the story. Over the past few years, marriage laws in the United States and throughout the world have been rapidly changing. As same-sex marriage becomes legal, a pink dot is placed on their map. There are a lot more dots to go.
It's a big deal. It is a big deal. And it's a big deal for us personally. It's a big deal for our families, for our communities, you know, and for, you know, for the American people, that we're heading into an era where equality is equality.
It's just been such a long, hard battle, and, you know, and that's something that we've gone through all together.
Yeah.
For legal analysis, we're joined tonight by Vic Amar, professor of law at UC Davis Law School. Also on our panel are Paul Rogers, San Jose Mercury News environment writer, and Michael Cabanatuan, San Francisco Chronicle reporter. Vic Amar, let's begin with you. What a week at the Supreme Court.
Indeed.
You know, we had been reporting that it was going to be at least 25 days before marriages began in California. Why do you think the Ninth Circuit acted so quickly?
Well, normally a lower court will wait for 25 days before implementing what the Supreme Court does to give the party that lost in the Supreme Court a chance to ask the U.S. Supreme Court to reconsider. But it's not mandatory for federal courts to do that. And the Ninth Circuit, I think, felt that, you know, marriage has been on hold for a long time since the plaintiff sued and won in Von Walker's trial court. And let's be honest, the chances that the U.S. Supreme Court would consider a request to look at this again are very small.
There was some question, though, at least the proponents of Prop 8 were saying that this was not a class action lawsuit and it only applied, therefore, to these two couples. And presumably they were going to test that in court. Is that now moot?
Well, the problem with that is is they never would have the standing to test that, just as they didn't have the standing to take it to the U.S. Supreme Court.
What if they could have found, say, a county clerk, you know?
That's still possible. A county clerk could refuse to issue the same-sex marriage licenses and could complain about that. But I think to do that against a backdrop when large parts of the state are already issuing licenses is a lot more politically difficult. So it might be that no county clerk even steps up like that.
I'm wondering if you were surprised at all by the lineup on Prop 8. It was Chief Justice Roberts writing for the majority to deny standing. Scalia was with him. Yeah. And then you had Sotomayor on the other side with Justice Kennedy. What was going on there, do you think?
Well, remember, the court didn't reach the merits of the big question of whether there's a federal constitutional right to same-sex marriage. Instead, it was looking at whether this group of proponents were the proper defendants to defend the measure. And that was a question, as you said, it's kind of standing. And when we talk about standing, the lineups are often kind of unusual because it has to do with access to federal courts rather than these kind of hot-button issues on the merits.
And conservatives tend to want to limit standing, right?
Often they do, although, for example, the dissent here was written by Justice Kennedy, who made, I think, a very good point, and that is, you know, even though the Prop 8 sponsors did not get elected by the people and therefore don't represent them in some sense, and I've been arguing for years that the Prop 8 sponsors lack standing, we have to find a way to make sure that elected officials don't get to kill initiatives, because the initiative device, after all, is supposed to be a check on their authority. So if the governor and the attorney general can destroy an initiative merely by not defending it, that puts a lot of pressure on why we have initiatives and how it's going to play out down the road.
Yeah, you know, the other big case obviously was the defense of marriage decision.
Yep.
And I guess the question here is, even with California now becoming the 13th state to support and allow same-sex marriage, that still means 3/4 of the states don't allow it. So what happens when one of these couples that's getting married right now moves to Nevada?
Well, there was a separate part of the Defense of Marriage Act that was not struck down in the court case this week that says states don't have to recognize same-sex marriages from other states. And that wasn't involved in the lawsuit. So right now, as things stand, if a couple gets married in a same-sex state and then moves to another state that doesn't allow same-sex marriage, they are no longer married. And they would no longer get the benefits that the federal government would give them in their first state. All that the DOMA case this week says is if you are married in a state and a resident of that state, the federal government has to treat you as married. But we have this untenable patchwork now, and sooner or later we're going to need some national solution to this. And my guess is that the Supreme Court will step in again down the road when there are more same-sex marriage states and maybe reach a different conclusion.
So maybe somebody who moves to a state like Nevada and tries to get the benefits and can't, then they file a lawsuit on that ground.
That might be the next step down this journey, where that couple might say, you know, it burdens my right to move around the United States to lose this valuable federal benefit. You know, it's a very incremental kind of a thing.
So you think it will take a judicial rather than a political or a legislative solution?
Well, you know, one of the interesting things about Justice Kennedy's opinion in the DOMA case is the first 2/3 of it talked about how marriage is a state, not a federal issue. So states have a lot of leeway, at least in the short run, to do what they want. But they're going to, demographically, same-sex marriage is very different in different parts of the country. We know it's different for older folks and younger folks, but it's also different in hardcore red rural states than it is others. So I don't know that in the next decade or so you're going to get more than 30 or 35 states on board.
So states don't have to recognize marriages from other states where it's legal, but does it complicate the federal benefits at all based on where you live?
Well, again, we're going to have to see what the lower courts do when they work out the DOMA ruling from this week. But traditionally, your federal benefits turn on whether you're married, and whether you're married turns on what your state of residence is.
And that's huge, because if you get tax benefits now for being a married couple in California and you move to another state that does not recognize marriage, you don't get those tax benefits anymore. And it seems to me that the big businesses in the country are going to realize this is a huge competitive disadvantage. If you're a bank or a Fortune 500 company in somewhere like North Carolina, some of your employees are not going to want to work there anymore. If you're trying to get top talent, they're going to go to banks or other top companies that are in states where they're going to be married. Why would someone move to a state and lose a bunch of benefits and have to pay more money?
And I think businesses are going to put pressure on legislatures to reconsider marriage laws, and they often have a big say in the political process. Indeed, you know, one of the cases we might mention, the affirmative action case this last week, built on the 2003 famous University of Michigan Law School affirmative action case. And a lot of people think the reason that affirmative action survived in 2003 and then survived again this week is because businesses want it to survive. So I think the relevance
and
of
the
businesses
military.
And the military. I mean, those were influential briefs filed in 2003.
I want to get to that in a second, but before we leave Prop 8, you know, the proponents of Prop 8 issued a blistering statement after the Ninth Circuit acted Friday, and they said, among other things, they called what the Ninth Circuit did an outrageous act. They said it was outright corruption and a dishonorable way to get to gay marriage. Is that just sour grapes, or do they have some kernel or more of a point to make?
Well, a lot of things about this Prop 8 case have been procedurally unusual. I'm not going to say they were wrong, but this case has raised a lot of kind of unique procedural questions, like the question of whether the sponsors enjoy standing in federal court. So I think the Ninth Circuit was within its rights to do what it did. From the Ninth Circuit's point of view, you had Judge Walker's victory in favor of the plaintiffs on the books a long time ago. They are the ones who issued a stay blocking that ruling from going into effect. The writing is on the wall. There's no way the U.S. Supreme Court is going to revisit anything, or anyone else for that matter. So this is like the last 2 minutes of an NBA game. Let's just get it over with.
Although we've seen some crazy endings to those games.
The Warriors first game in San Antonio. Fair enough.
Let's move to the affirmative action decision. The University of Texas, a case brought by a white student, and the analysis was that they let they kind of punted and kicked it back down. What's your read? Is affirmative action safe for the time being, at least as it exists?
It is safe for the time being. I think proponents of affirmative action were very worried that Justice Kennedy, kind of the fulcrum of the court on that and a lot of other issues, would join the more conservative justices to impose a flat categorical prohibition on colleges using race in admissions. And indeed, when the court granted cert, a lot of people speculated that maybe there was reason to believe Kennedy was moving in that direction. Kennedy did not do that at all. Kennedy simply said, the lower court, in this case the Fifth Circuit Court of Appeals, really didn't look hard enough at what the University of Texas had done, and so the court sent the case back down to the Fifth Circuit to apply a little bit more careful review, but it left intact the legal framework that we've had since 2003 that allow universities to take race into account. And my gut sense is that universities are going to continue to do more or less what they've done now. They may have to explain things a little bit more crisply for why they're doing it, but this preserves affirmative action for a while. But
California doesn't really have affirmative action.
Well, because we have Proposition 209, which prohibits it, and so does Michigan and a few other states. But if you kind of compare this to one of the other big cases from this week, the Voting Rights Act case, there, 4 years ago, the Supreme Court basically sent a message to Congress that the Voting Rights Act needs to be reconsidered, and it was not modernized, and it wasn't really carefully crafted. And Congress didn't do anything, and 4 years later, the Supreme Court says, okay, your time is up. We're going to strike down the provision. So they did it. It might be somewhat true for affirmative action as well. If universities don't take this opportunity to really fine-tune affirmative action and make it a little bit less aggressive when that aggression might be harder to justify, you could find Justice Kennedy joining a majority in 5 years that closes the door more tightly.
But in the Voting Rights Act case, I think they said, Congress, you can fix this, just get new data. And I think, was that really sincere? I mean, how likely is that to happen?
In theory, that's sincere. But you know, the court is acting against a backdrop where it knows that Congress is dysfunctional. And what are the chances that this House of Representatives is going to agree with the Senate on this dicey issue? It's like saying in the Affordable Care Act case last year, the Obama Care Act, if they just said, okay, Congress, write it a little bit differently, it wouldn't pass Congress. So the court has to understand that when it invalidates a federal law that's on the books, in this climate, that's not just a temporary kind of block. That's a permanent rebuff.
It's interesting to hear Scalia in his dissent on DOMA saying, how dare we invalidate, disregard the Congress, and yet isn't that exactly what they did, what he did
in the Voting Rights Act?
He
would, if he were here, he would explain how the two cohere with each other. But the interesting thing is, in the DOMA case, in his dissent, he basically said Justice Kennedy's opinion, even though on its face it purports to strike down only the DOMA and it leaves intact the laws of the 37 or 38 states that prohibit same-sex marriage. Scalia said, look, the reasoning is quite clear. That means that all states are going to have to accept same-sex marriage. Chief Justice Roberts, who also dissented in the DOMA case, took a very different rhetorical tack. He said, I disagree with what we're doing today as a court, but let's be clear, what the majority is doing has nothing to do with what the states have a latitude to do. So it's, I mean, Scalia wanted to score rhetorical points, and I think Roberts wanted to tell Justice Kennedy, hey, if your mind isn't made up about this, you haven't yet boxed yourself in.
And you know, on Prop 8, it just reminds you how important elections are, because if you think back to when Kamala Harris was elected, she barely beat Steve Cooley, the Republican from Los Angeles.
Who would have defended Prop 8.
He would have defended, there wouldn't have been a standing question. It might have turned out quite differently.
And I think a related point is that, you know, Governor Brown and Attorney General Harris decided not to defend, which was a very momentous thing to do. And because when the sponsors were in the case, no one was really paying attention to that. Now, it turns out that's really what doomed Prop 8, is their failure to defend. Yeah. And the politics in the meanwhile have changed such that they don't really have to pay any price for that.
All right, and the weddings have begun. Vic Amar, thanks very much. President Obama has made a sweeping call to combat climate change. In a speech in Washington, D.C. on Tuesday, the president called for the nation's first mandatory restrictions on greenhouse gas emissions from new and existing power plants.
Power plants can still dump unlimited amounts of carbon pollution into the air for free. That's not right, that's not safe, and it needs to stop.
Paul Rogers, how big a deal is what the president did this week?
It's a really big deal, and you know, it's the single largest initiative that the federal government has ever taken to limit climate change. It's also the most significant environmental action that Obama has taken since he's been president. Up to this point, the most significant action was when he doubled the gas mileage of automobiles from 27 miles per gallon fleet average to 54 through 2025. And what's so interesting about this, we're talking about elections matter and Congress and all that, actually made me think Justice Kennedy took the place of Robert Bork. And who was the chairman of the Senate Judiciary Committee that ousted Bork? Joe Biden. And Kennedy also played a key role in a Supreme Court case that deals with this global warming decision as well. In 2007, the court ruled 5-4 that the EPA could regulate carbon dioxide as a pollutant under the Clean Air Act, just like it regulates mercury and lead and soot and other types of smog. And that was a landmark ruling because it meant that the EPA administratively by itself could write rules limiting global warming emissions from coal-fired power plants and almost anything else without the approval of Congress. Now, when President Bush was in office, the EPA did not try to do that. When President Obama came in, he said, let's have the Congress try it first. And folks might remember when Nancy Pelosi was Speaker, they passed a bill in the House, and then the bill died in the Senate because it was filibustered. So now this is Obama saying, all right, we're going to go to the EPA and go around the Congress.
So if he could do it unilaterally, why did he wait so long?
Because I think, you know, it's politically better to let everybody participate in it, to let industry have a seat at the table, to let environmentalists have a seat at the table. You can say that it's a compromise because, frankly, for many years, Republicans have said that Democrats have a war on coal. We all remember Mitt Romney's ads in Ohio last time around, and the Democrats always deny it. But the Democrats do have a war on coal. You have to have a war on coal if you think climate change is real. And the reason is because coal is the single largest source of climate or CO2 in the United States. And if you don't do anything about coal, you don't do anything about climate change.
So when is the EPA going to pass some or propose some rules, and what are those rules likely to do about power plants and coal in particular?
The draft rules should come out by June of next year, and nobody knows for sure exactly what they're going to do, but one likely way this is going to play out is that the EPA is not going to say there's a set number for every power plant and you can't emit any more than this amount of greenhouse gases. Instead, they're going to do what they do with automobiles, which is to say, what's the fleet average? So just like the EPA goes to the car makers and says, you have to average 27 miles per gallon, so you can make a bunch of SUVs that only do 12 miles a gallon, as long as you make little cars. They'll do that with power plants. And so you can keep some coal power plants, but you have to have more natural gas, you have to have a lot more renewable, you have to do energy efficiency measures. And that's going to be a huge boon for Silicon Valley, which invests in and makes, you know, the software that helps the lights go out when you leave a room, that does a lot of green building technology, that does big solar, big wind. This really, there's almost, I can't think of a single downside for the state of California. Nobody's power bills are going up in California because we already have a state law in place limiting power plant emissions. It was Arnold Schwarzenegger's AB 32. We already have a law that Jerry Brown signed that said 33% of our electricity has to come from renewables. So for California, everybody's just catching up with us.
And these regulations that are going to be issued eventually, are they then subject to lawsuit?
Oh, sure.
Yeah.
Well, as our legal friends
if you
can
have
tell
a new
us,
president coming in and a new EPA in 2016, can these things be undone? Or how, I mean,
well, plus you've got the district court in D.C., which kind of gets the final say. That's a whole other
DC
political
circuit.
battle.
Well,
the circuit court.
Don't forget the Supremes have already said that the EPA can regulate this. This was the big thing. President Clinton is not likely to overturn these rules. And keep in mind, the science. The science
is that a prediction?
Yes, it is. The science is very, very clear on this, and the science is only getting clearer every year. The 10 warmest years since the 1880s, when records were first kept, have all occurred in the last 15 years. The ocean has risen 7 inches in the last century. All the big ice caps are melting. You know, this is happening.
All right, Paul Rogers, thank you so much.
Thank you.
One of the things, of course, that would help with emissions is public transit, right? But commuters may find themselves in transit chaos as early as Monday if BART workers go on strike. Negotiations over wages, health and retirement benefits, and safety issues have stalled between management and 2 of BART's largest employee unions. The last BART strike was in 1997 and lasted 6 days. Michael Cabana-Tuan, first of all, give us a sense of where are the talks between BART and the unions.
Well, they've been talking since May, which is kind of a late start, but it seems like they finally started making some progress yesterday. You know, BART and its unions have been known for walking right up to the deadline and getting a settlement, and I think a lot of people just figure, well, that's what's going to happen every time. This time it seems like it may be a little different. They seem farther apart. They seem like they're not really moving closer together, at least not very quickly, and there's an anger among some of the employees. 4 years ago, they not only forfeited raises, they took a contract without raises, but they also gave up $100 million in savings to the district, $100 million in concessions. So this time they're saying ridership is up considerably. It's increased 6% each of the last 3 to 4 years. And they're turning maybe $100 million, $125 million surplus, and they're saying, so share the money.
So give us a sense of, you know, relative to other transit agencies, either in the Bay Area or elsewhere, how well do BART workers do?
BART workers do very well. They get decent salaries, good salaries.
You have an average number, or is that just too hard to really?
You know, for a station agent, you know, it's hard to, averages kind of mess it all up.
Yeah.
But for a station agent or a train operator, they typically make salaries that are in the $60,000 to $65,000 range, a little higher, a little lower in some cases. As BART will tell you, they also make an average of $10,000 to $15,000 a year in overtime. Of course, you have to work overtime. And then they have generous pensions and benefits, at least generous compared to what most of us get on top of that.
Yeah.
So are the big sticking points salary or pension contributions or health benefits? You know, you said that they're kind of farther apart this time than in the past. What are the areas where they're the farthest from each other?
Really, they're all kind of linked together. You know, basically they kind of consider it economics. It's an economic package, and you know, my guess is that whatever the solution will be a combination of you know, of pay raises, contributions to health care, contributions to pensions. The unions are also making a big deal about safety, and I know some people say that, well, you know, that's just a ruse, but truthfully,
safety. What is safety meaning? What?
Safety, basically in 2 areas. Safety in terms of the station agents who have been the subject of a lot of assaults. I mean, both from people spitting on them to people hitting them. One station agent recently had to, you know, lock herself inside her her glass box.
Yeah.
I think we've all seen the video of the guy who went crazy in the Mission Street BART station. But also the safety on the tracks. There have been a couple of workers who've been killed, struck by trains while working on the tracks, and at least in one of those cases that occurred near the 24th Mission Station, there's a question of whether there's adequate lighting.
Yeah. The BART union is asking for a 23% raise. The average gross pay that I've read that they make is $83,000 a year. They pay nothing into their pension. They're one of the last public groups that pay zero into the pension. 400,000 people a day ride BART. If BART goes on strike, the entire Bay Area is going to be gridlocked.
Right.
Even in a liberal area like the Bay Area, how's that going to play out when people learn more of the details about what the folks are asking for at BART?
Well, I covered a little bit of the 1997 strike. I had just started at the Chronicle, and what happened is people started out being angry at the workers. They ended up being angry at both, basically saying, "Why can't you settle this? You've both got valid points, but why don't you settle it?"
As Paul said, could be a mess on Monday. What's being done? What kind of plans are having? Contingency plans, flex time, and what are employers saying? What are the local governments saying?
There are contingency plans, and the Metropolitan Transportation Commission, which is sort of the Bay Area's transportation planning and coordination agency, is trying to make all the different agencies, and there are 20 plus transit agencies in the Bay Area.
That's a whole
work
other
together.
story, right?
Yeah, exactly. But they're urging telecommuting. They're urging people to travel during off hours. And here's a tip: when they say off hours, most people go early. If you go late, sometimes you can get through a little bit.
Quick prediction.
Right.
He's here full of predictions
Real
tonight.
quick prediction. I'm asking you for one now. What percentage, 0 to 100, likelihood do you see that they settle this by Sunday night?
That's the tough question. Until yesterday, I would have said I was almost absolutely convinced. I was probably 90% certain that there would be a strike. Now I'd say, I don't know, maybe I'm 70% certain there will be a strike.
So you have a lot of people on Monday morning listening to the traffic reports on the radio and television to see what the heck is going on.
Oh, absolutely.
All right. Well, that is all the time we have. Michael, Vic, and Paul, thank you all very much. Have a great weekend. Well, for more in-depth coverage and reaction to the Supreme Court's decisions this week, go to kqed.org/thisweek. One program note: we are off next week for the July 4th holiday. Next week is also the 40th anniversary of the iconic Sutro Tower in San Francisco, which provides the signal for many Bay Area broadcasters, including KQED Public Television and Radio. I'm Scott Schaefer. Good night. Have a great weekend.